Good afternoon, sir.
Hello.
One student is going to read out the profile.
Good afternoon to one and all. This is Madhvi presenting the guest profile of our today class lecture, Mr. Srinivas Maddipati, Managing Director, Eeva IP and IT Service Private Limited, Hyderabad. Mr. Srinivas Maddipati is the Managing Director of Eeva IP and IT Service Private Limited, Hyderabad. Srinivas is responsible for IPR consulting services at Eeva at Hyderabad and Visakhapatnam. He is the Managing Partner of Eeva Quality Certification Services, Hyderabad. He is a certified lead auditor for ISO 9001, 14001, 45001 and 27001 standards and does third-party consultations and audits. He is the President of Educational Society for Intellectual Property Rights, Hyderabad. ESIPR conducts sessions to extend awareness regarding IPR. He is designated partner in Highviews Patent Illustration Services LLP, Hyderabad. The company provides offshore patent illustration services for US and European patent attorneys and technology companies. Thank you, sir.
Thank you very much, Ms. Madhvi. I think it's your name, right? Okay, thank you.
Yes, sir.
So, is the screen visible?
Yes, sir.
Yeah, and the voice is audible, right?
Yes, sir.
Thank you. And can I know the audience, who are they actually? 30 years, 5 years, which branch? A brief about it. No, I mean to ask who are all the audience today? Madhvi.
Yes, sir.
Who are all the audience?
We are third
What is
BTech
the screen?
students, sir, for minors from different branches.
Okay, 3rd years and
Yes, sir.
okay. So I think you are all about know about IPRs, right? The basics of IPR, no need to touch. So we are talking about in advanced level of IPs and their ownership rights and transfer of IPs. Anyway, I'll touch upon briefly about what are these IPs are and what are the types of rights each IP will have, and then we'll deep dive into more of how to transfer the rights and how to see the transfer of rights. So first of all, thanks for the opportunity given by Vignan Institute. So we are actually continuously associated with Vignan Varlamudi as well Vignan Vizag and Hyderabad. So first to start with, the IP chain of activities begins with a creation, means with an idea, and then development of idea, we call it as innovation stage or maybe the prototyping stage, and then creating a right for the innovation, means the obviously ideas cannot be patented or ideas cannot be protected. Only the creation or the next level of creations that are the products or services can be protected under IPs. And the next stage is commercialization. So it can be commercialization by the IP holder or the inventor, or commercialization through other channels like third party may commercialize these IPs. Give me a second actually. Yeah. And then commercialization protection can be before commercialization, and what we are talking about filing IPs and protecting them. and then commercialization, and after commercialization or during commercialization or any time after protection, they can be enforced. Means like if there is an infringement, so we can enforce through different channels. So it can be through negotiation, it can be through a legal suit as well. If someone is infringing and they are not actually like coming to a dialogue with us. So these are the IP chain of activities. So in which this session we are concentrating on the stage or the activities related to or around the commercialization aspect, and a brief about when we are actually protecting them as well. So IP is considered as an intangible property. So there are tangible properties that we know. So we know land, houses, estates, cars, or our personal belongings can be considered as tangible properties. And these IPs are intellectual properties like patents, trademarks, designs, copyrights, and other rights can be are treated as intangible properties. So intangible properties is wealth equivalent to tangible properties, but proper documentation and a right need to be procured so that like they can be enforced. So IP as a property, this intangible property can be sold, can be bought, can be leased or rented, can pass under a will, or can be assigned. So that means like equivalent to tangible properties, IPs can be sold, bought, leased, or can be transferred to others. So IPs are different forms of IPs, and in them, the main important or maybe popularly sought are patents, trademarks, and industrial designs. And certain part of the inventions goes under copyrights, and there are other IPs called IPs like geographical indications and plant varieties. So typically, we will discuss about a life cycle of how to pursue a patent. So obviously, it starts with a patentability search. Example: if someone coming to or coming up with an idea of inventing a EV vehicle, EV two-wheeler, or maybe EV some sort of a three-wheeler or four-wheeler. So in which the EVs are known, but thing is like there is a white space identified by this inventor, and if this white space can be searched and if can be identified, the IP can be identified or the patentable aspect can be identified, then we can actually proceed with an application filing. So anything, not only EV, it can be a business idea, it can be something related to pharma or maybe some drug, or it can be an engineering or known article, or it can be an unknown thing till date. It can be a flying car, or maybe it can be anything of that sort which human needs, or maybe an animal also needs, and if it can be sold as an article, so that thing can be protected under patent, and then these are the steps. Like typically, anyone who want to patent need to search, so they can do the search by themselves by knowing how to search using different databases, because there are patent offices of each country, where like these patent offices will collect applications filed in that country, and they'll publish first for the access of public, and then they'll conduct an examination and issue a grant, issue a patent. So after issue of patent also, they'll again publish these documents. So there are certain documents. It can be patent applications or patent grants, and it can be journals or public journals, or maybe private websites, or maybe private articles. All of these are considered considered during the examination of a patent application, not only limiting to one country. For example, if this application is filed in India, it is not that like Indian Patent Office will conduct a search and do an examination only on the documents available in India. It is something like a global search. It means they'll search using paid databases, or they perform in multiple databases, the patent office, and they'll collect all the information that is available prior to this application, and then they'll compare the patentability criteria. So the patentability criteria are the inventive step, that means newness of the application, and industrial applicability and non-obviousness. So they'll compare on these three criteria while they do the examination, as referred in this image, step 5. And after the step 5 and 6, and after the examination, if it is like if the application or the agent or the applicant successfully proves that these three steps are there in the claims of this application, then the patent will be granted. And subsequently, after the grant, like it need to be renewed every year, starting from 3rd year. So this is the patent application life cycle. Likewise, the same likewise a similar life cycle for trademarks, designs, and copyrights as well. But not very critical. Trademarks, designs, or copyrights are not that critical when compared with patent applications. And obligations of patentee. So patentee is who the patent is awarded to. So we call him patentee. The applicant of the patent application after grant, we will call him patentee. That is the rights owner. So what are the obligations of patentee in terms of or till he gets a grant? So his obligations is to disclose. We will start from the left hand. So duty to disclose. So the patentee's obligation or the applicant's obligation is that he has to disclose what is there till date. That is, he has to disclose what is the problem statement, and then what are the implications with that problem. Like it can be financial implications to the user, or it can be technical implications to the user using that particular subject matter. So he has to disclose properly a problem statement, and then his proposal, his objective of inventing this particular device or a process, and then he has to provide experimental or some sort of comparative analysis when compared with the existing solutions. And then a proper claim. Proper claim means like under the claim section, he has to describe his invention. So the inventive step and the usefulness of the invention in that part. So this is his primary duty, to disclose proper and sufficient information so that like he can be granted a patent. And then he has to the next obligation after this is while filing. So after filing, no one can actually add contents or maybe information to the patent application. All that they have to do is, while they are actually filing, the complete specification on top of the application file. So the next duty or the next obligation of patentee is duty to request for examination. Why it's a separate thing? Like applications filing is one stage, and request for examination is another stage. Why these are actually detached? Is that this application which we are filing, is that not for examination? It's not like that. So the patent office deals the application as a stage, and request for examination as a separate stage. Though they can be combined, means while the application is being filed, the applicant can ask for examination, But why it is been dealt separately is a third party can also request for examination of on top of an application. That means like if I am filing an application, someone from you, if you after seeing my application publication, so you can also ask for examination. Means you can ask patent office by paying that fee, examination fee, because you are interested to commercialize maybe that product. So because of this chance, the third party can also request for examination. So these two stages have been separately dealt. So first duty is to disclose proper sufficient information to the patent office, and then an examination request by the applicant is also his obligation. And then once the application for examination is filed, so the patent office takes the application for examination, and then they'll issue an objection report or the examination report, in which there can be a couple of or maybe more objections related to the patentability criteria, and this is his obligation. Patent is obligation that a proper response need to be filed within the time limit given. So the time limit given is 6 months till recently, and now it has been or is going to be reduced to 2 months, 60 days only. Previously, it is 6 months. And once it is his obligation to clear if there are any further objections, and then it is his obligation to pay a renewal fee after the patent grant to have this patent in force. And what are all the rights of patentee? What they get after patent grant? What they get? So what they get or what they are given with the patent grant is, so they can obviously right to exploit. So they can means they can commercialize the product, and they can stop others from using this or doing business of this invention. And it is their right. They can actually license to someone who is manufacturing or who is capable of manufacturing this product. And obviously the other right is to he can surrender, means like he can withdraw the patent as well. So if he is not interested to exploit the market or commercialize the patent, he can withdraw. And if there is an infringement, he can sue someone, or means he can stop by enforcing his right in a court of law. So rights of patentees are to, or if we combine or summarize the rights, so the right to claim damages, monetary benefit, that is his right. The right of sale, he can manufacture and sell, or he can sell out the patent as well. And the other aspect is like through licenses or royalty agreements, he can the patentee can leverage or maybe get some revenue out of those licenses of use. So these are the three types of revenue streams for the patentees. So, and if we see the commercialization of IP life cycle, so first we talked about idea and documenting the idea properly, and searching by themselves, as well by taking maybe a third party's help, like a patent agent's help, for searching different databases, because there are each country has a database, and it is tough for inventors to have a paid database access. So for that reason, they can engage someone who has a database access and who is proficient in doing this patent search. So they can do themselves as well. They can take an IPFC or a professional's help in searching this idea, whether to see it is patentable or not, analyzing the results, then deciding whether to file utility patent and as well design patent or both, and write a document or write that patent application draft for filing an application. Then seeing through the patent application process, that is having that application examined, successfully clearing off all the objections and getting a grant, and then renewing every year, proceeding to presentation or maybe public display of the idea, the product, and then as well the patent document if required. This stage we are calling like commercialization or maybe startup incubation stage, where like this idea can be or this patent can be traded by themselves or maybe through partnerships, through collaboration, through licenses to other companies. So this includes either getting a finance or funding from outside as an investor coming in, investing in this company or in this startup, or through licensing or maybe other channels like royalty agreements, giving the technology or technology transferring to a right channel partner or maybe a manufacturer. If we are doing on our own, like the startup or the inventor doing on his own, then taking a finance and market. So this is the commercialization of IP, all starting from idea stage. So this is the life cycle. So any question? Audio is audible, right? Anyone from the audience? Madhvi?
The audio and screen is visible, sir.
Yeah, thank you. So next slide, actually, I wish to start the transfer of IP or maybe this ownership transfer related stuff. So transfer of IP, things to know are the before selling an intellectual property, we need to study the market. So we call like till now, if you value our IP, if you value our patent, so this is till now it is a cost that we spent. That cost means it's not only the amount we spent, even the time we spent. So that is from the idea stage, developing it, then sitting with the patent agent or attorney, filing an IP or filing patent designs and other IPs, seeing them or getting them through, means completing clearing all the objections and getting the IP rights and actually paying the renewal fees, and then prototyping maybe with the help of incubating somewhere in an institute or maybe in an incubation facility, or spending personal money so for prototyping. So all these things till now it is something like if you value at this stage, like from the idea stage still IP creation and prototyping. So if you value this stage, we have to do it as a cost-based approach. Means we have to calculate all the costs, the physical infrastructure being procured, the cost spent and the time spent. We have to calculate, and it is a small value. It will be a small value in terms of because like we still not know or we still don't know the market whether this product can be sold or not. So till here, like it's an assumptive approach, or maybe the um, the path is still now is assumptive. That means like it's all about assumption of the idea, I mean, assumption of the inventor. So from here, like if we see, like it is something like we need to do a market research and then based on the market research, we can value our IP. So things to know before selling an intellectual property is that like the inventor or the applicant, the patentee has to know what are all the things we will take for the market research, and then we have to proceed with doing a market research and combining the cost-based calculation and market research-based calculations. IP can be traded, can be shown to someone, interested party, so that we can commercialize it. So consideration to transfer an IP, if it is a single ownership or maybe joint ownership, types of IP and data ownership models is like this. Like single ownership, it's all like the whole calculation required by one person. Ownership, like it is like again contract between the ownership. If it is like once it is if there is no contract again, like it is something like all the owners or all the applicants will have equal ownership, and if someone wants to go out and or maybe commercialize this on his own, it's a challenge to inventors in terms of maybe colleges working on or institutions working on an IP, and if there is no proper agreement in place before filing or after filing before grant, and if this patent grant or maybe design grant is likely to get commercialized or there is a chance of commercialization, then there will be a conflict of interest between the parties. So this need to be understood before starting this um, commercialization step. So assignment or the transfer document, we can say, so assignment of IP will be black and white, means like it need to be a sale deed. So between the owners of the owners holding the IP, and then whoever is actually taking the IP. So assigner and assignees. So there should be an agreement, and what are all the requirements for actually making an assignment of IP, or like one is having this sale deed for the consideration amount which is being negotiated on, and then this agreement need to be secured, means like this agreement need to be registered for that value with a proper stamp duty, like we register our sale deeds related to property or maybe other valuables. So the same way, in the same process, so we need to register this agreement, and then this agreement to effect in the patent office or in the trademark registry. So to change the ownership in the patent office or in the trademark registry, we have to send this copy of assignment, copy of the registered deed, along with certain forms as per Patent Act and Trademark Act. Then the transmission or then the transfer of right, inclusion of the new owner or the uh, patentee will be affected in the patent office and the patent registry or in the trademark registry. Even the licenses also, like if it is not a transfer, this assignment deed, we are talking about assignment deed in case of a complete transfer or maybe holding the IP on a joint ownership. But if it is not a transfer, means like we are not adding or we are not transferring the right to anyone. Only we want to license it, means for 1 year or maybe multiple years. Then in that case also a license agreement need to be registered, and this license agreement need to be provided to the registries. It can be copyright under the Copyright Act. For copyright registrations, the licenses need to be registered officially with the Copyright Office. And even it is not mandatory with the patent applications, but there is an obligation for patentees that every year they have to file a statement of use on the patents they have. Means if I have a patent in my name, like I have to file my statement of use every year, every financial year. In that, we need to mention if there are any licenses we have given, and if there is a revenue out of those licenses, we have to include, or we have to mention those revenues in this statement of use. So like this, the documentation pre-transfer, pre-licensing before commercialization, and during commercialization or during transfer of right. So the documentation is very important. This license deed or assignment deed, transfer deed is very important to have all parties' rights intact. And we are talking about trademark or patent as similar in nature. So we are talking about assignment of trademarks or patents, or transfer of trademarks or patents. But corporate ownership terms are a bit different. So copyrightable items are literature works, artistic works, sound recordings, and video recordings, including the softwares. So these five items, these five natured items, means it can be books, literature work, artistic works, sound recordings, video recordings, and softwares. These five types of things comes under copyrights. So this ownership of copyright and their terms are a bit different when we compare with patents or trademarks and designs. So the term work, as per Copyright Act, is defined as the work, means like if it is a literature work, so that book is considered as a work, and if it is an artistic work or a sound recording, also it is considered as a work. And then authorship, I mean, ownership is actually defined as authorship. Means like they'll call authorship, like means the author will have a complete ownership, and there can be multiple authors or maybe multiple co-workers. In terms of, for example, sound recording, the other artists, there are any like the lyricist or the drummist, all these people will have equal rights. In case of video recordings, means like a movie, so even the hero, heroine, or the other artists will have ownership. So this ownership need to be documented, like whether the production house or the producer will have all the rights on reproducing or maybe translating the work. These need to be properly documented. Even the corporate application will have all these sections. The corporate application on Form 14 as per Corporate Act will ask all these questions, whether how many are the authors, and whether all the authors are owners or not. And if all the authors are not owners, if there is we need to provide an NOC, no objection certificate, from the others, declaring their transfer of right. So even the application stage itself, or the application itself as per Copyright Act, will define certain things, and these are different when compared with other forms of IPs. And transfer of right, once it is defined, like whoever are the authors in the copyright registration certificate, they can transfer the rights. And again, the transfer of right by writing an assignment deed is same as patents and trademarks. So transfer of copyright, specifically we have to, for example, films and sound recordings. So this transfer of rights, so we will define the ownership within the copyright registration certificate itself. And if there is no registration, for example, Copyright Act doesn't mandate registration. Unlike patents, unlike design patents, unlike trademarks, Copyright Act doesn't mandate a mandatory registration. So then in that case, we have to define all these things within agreements. If there is no copyright application being filed before publication of the work, in that case, so this ownership remission or ownership having by only one person or a company need to be defined with an agreement. And copyright vests with the author owner upon creation of the work. That means immediately after creation of the work, the ownership will be given, or ownership will be with the authors, all the authors. For example, someone is publishing a paper, so the co-authors will have, means there is no one, two, three. Like the first named person will have more right, second named person will have lesser right, as per Copyright Act. So who are all the authors? So they will have equal ownership. So the transfer rights can be defined with a copyright registration or with an internal agreement. So assignment of copyright, again after the initial documentation through a copyright registration or an agreement between the parties, then the owners of the work can actually assign this right to others. This is one different aspect in copyrightable works. So authors of literary and musical works forming part of a cinematographic film. For example, the story writer and the lyricist of a movie or album, audio album, have special rights to receive royalties that cannot be assigned or waived. Means this author of the movie, the story writer of the movie, or the lyricist of the songwriter of the audio album will have undeterred, means like they will have a right. Though, for example, someone producing this album in Telugu, and they will have right on that album which is been made in Telugu, but the authors of the work, they will have this right to translate it, or maybe to improve or maybe rewrite it in any other language, or maybe in the same language also. So they will have that undeterred or unwaived right on their writing, because it's again a creative work. So creative work can be, creative work can be reviewed or maybe rewritten. It can be rewritten into multiple versions. So manner of assignment in terms of copyright. So again, same like other IPs. So it can be transferred completely for a payment, or it can be licensed for a term for a payment. The term need to be defined. A payment need to be defined in the agreements, and the agreements need to be registered. There is a concept of reversion of rights in copyrights. That means like if after taking an agreement, means a license agreement or maybe a performance agreement, if someone is not performing, means like a small movie is made by maybe a group of people, and it has been given to some production house, or maybe someone who can publish it. I'm taking an example. And if they are not publishing it, so under the agreement, we have to write that agreement. Like before giving it to him, we cannot do it orally. So if we are giving it to him for publication, and if he is not publishing it within a year or maybe within a specific time, then we can actually give a notice to him saying like we are reversing whatever the commitment we are giving to him for publication or maybe for usage. And IP rights enforcement, altogether it can be any IP right, patent, trademark, design, or copyright. So enforcing of IP is through courts. Means it need to be, a notice need to be served to the party for the deferment or maybe whatever the promise has been not followed. So we can enforce by giving a notice, giving a certain time under the notice, 15 days or 7 days time. And then if they are not responding, we can then proceed with a filing of suit in a district court. So all the district courts based on the jurisdiction. So the jurisdiction will be the jurisdiction where the IP holder resides, or maybe the party who is actually taking this for royalty or misusing it, or maybe infringing the product. So that can also be the jurisdiction, preferably in the jurisdiction or preferable in the place where the IP holder sits, or IP holder has a residence or place of business. So enforcing IP through mediation, arbitration, through other negotiation approaches as well, methodologies as well, or through filing a regular civil suit on the person who is infringing the rights. So this is another aspect of like creating IP, commercializing, trying for commercialization, transferring, assigning the rights, and we are talking about the enforcement of IPs. So I think like we are a bit in a hurry. So though we started to 15, we have much time. Fine. So we are into third aspect of IP rights enforcement. So enforcing IP rights is crucial to protect against infringement and unauthorized use. The whole the purpose of filing IP is taking that pain of getting an IP, spending money, time, and then renewing them as well. So trademarks need to be renewed every 10 years. So first they are provided for 10 years, and again every 10 years we need to renew. Patents, like though it is given for 20 years on application, starting from third year we need to pay a renewal fee. And for a natural person, the renewal fee starts from 800 rupees and increases 3 times every block. In every 5 years means like 3 to 6 years, it is 800 per year. And after that, from 7th to 10th year, it is 2,400 per year. And if it is natural person, like it is a normal entity, natural persons, small entities, institutions, startups, all in a category. And there is another category which are not natural persons, or which are not small entities or startups. So that is another category. So their fees is even more. After taking all this pain of creating IP, filing, getting prosecuted till the grant, till the acceptance, and then paying renewals, all this is the objective of this is to enforce it in a case of infringement. And this enforcement is not default, or maybe not taken care by the patent office, or not taken care by any other agency. Again, this is again the responsibility or obligation of the patentee or the right holder. Again, he has to make an application, or means approach a court, so that like court need to give a direction against the party infringing to stop or to pay damage to the patentee. So all these need to be understood by startups, or the entities, or the inventors who are actually starting their journey of innovation, because it's not that easy. So having an idea is not enough, but protecting it, valuing it, and then enforcing it if it is required, if there is an infringement, is very much important. So regulatory monitoring the sorry, there's a typo here. So regularly monitoring the market for potential infringements and take prompt legal action when necessary is very much important, and maintaining proper records and documentation to support any claims of infringement. So this is a very important thing. So what inventors do normally is like they'll write something like 2-3 pages document on request from a patent agent. So people come to us saying like, I have an idea, I want to patent. and all the documentation or the homework or the notes they will have is nothing in most of the cases. I mean, I'm not talking about the institutions or the academicians. So they'll have, like, if they are doing some work, they'll have a certain documentation in place, because they also, I mean, along with the filing of the IPs, they'll also try to publish this in different journals. For that purpose, it's their habit. Like, they'll create certain documentation base, like they'll do the literature research, they'll do proper documentation of the literatures that the citations they find, and the analysis they do, like the comparison between the cited documents and the present invention. They'll have certain, at least in percentage wise, if we see, like 80%, 90% documentation which is required will be there with them. But from the grassroots inventors, or maybe from the student fraternity, or maybe any other people, even from the small entities and startups. So there will be very little documentation on what they actually want to do, or work on their ideas. So it is very important during enforcement. It's not the patent application is just enough, because if if you approach a patent agent and you just orally say your invention, he'll also, after listening to your invention, he may record the same, and he'll convert whatever the conversations you had with them, and he'll convert that text into a patent application and he'll file. The invention must be very good, means like it should have had that criteria to get a patent grant, and you may get a patent also, grant also. But in a case of infringement, and when we are actually going for enforcing our right, and if the other person, whoever is infringing, or that company, shows that they are also working on the technology from more than 10 years, with different pros of their trials and prototyping on the same concept, then what happens for our right? That means, like, so it is obvious. So the court may direct the patent office to relook into the patent approval process, and then we may lose our patent as well. Means like that patent gets cancelled or revoked. So this happens if you don't have enough documentation showing. It can be in any form. It can be in the computer disk, it can be on the notes, it can be on the charts, it can be through photographs or videos. But proper, from the idea stage till we develop the product, and in the process while creating the IP, we need to have everything documented, and we need to have a copy. So we saw many cases where, like, the other parties, the defendants, come up with a lot of documentation, like I explained now. So they'll show 2, 5 years or 10 years of their usage as well, or their process of developing that product. Like, they should have already had a product which is inferior than what we are actually having as a patent. But after seeing our patent, like, they should have developed that product to a more superior product than us. So in this scenario, they'll go out without any fine, or maybe without any liability. Even we try to enforce our right, because they have a product they are already manufacturing. Means like, what to be improved, and he'll improve more than what we proposed in our patent. And then even we try to enforce our right, they'll just slip out from the clutches of our patent grant. So maintaining a proper record and documentation, so to support any claims of infringement, is very important in during enforcement stage. And this we cannot create at that point in time. This we need to have as a mandated process, or maybe during the from inception of the idea, like we need to have all that what we thought of, what we tried, what we tested, and all. So international IP transfer and licensing. So whether this IP transfer can be cross-border or we can license our IP to any party sitting outside our country, yes. There is like though the IP is only valid in a particular territory, means like if we have a patent grant in India, it is only valid in India. There is a chance for applicant during the examination or after filing the application, initial application in one country, there is a chance like he can also file in other countries. Obviously, there are costs, but a 1 year time is given for filing all the international applications. Means in all the countries wherever they are interested. If not, there is an extension of time through an international application called PCT. So through these channels, like they have to get all the rights in all the interested countries. If not, if the party coming in to take our technology for licensing, then it is not barring. He won't care like whether the right is only in India, and most of them, like if someone is coming, seeing our product, seeing our demo, seeing our website, seeing our product in YouTube or maybe on other platforms, or seeing or buying a product from India which we are making. If they want to make it in other country, they'll definitely approach us for technology transfer because like they need. So not all the products can be easily made by just seeing the product. So for that reason, they'll definitely ask us for technology transfer or a license, though we don't have a grant or patent in that jurisdiction. So that means like IP transfer or international IP transfer is one more available window for an IP holder for acquiring some wealth out of this IP. So transferring or licensing IP rights internationally requires understanding and compliance with different legal frameworks and regulations. So we need to understand what is the documentation formality that we need to license an IP to a person maybe about Singapore. Means if you want to license our technology to a company in Dubai, then we need to understand whether this assignment deed or the license agreement, whether we can register in India or we need to have it registered in Dubai as well, so that it holds. And if there is a dispute in the agreement, like there should be a clause, the jurisdiction need to be mentioned. If there is a dispute in the terms, so in future, so how they are need to be resolved. So this understanding is very key in case of international IP transfers or licensing. So that's it. Actually, I concluded thinking like we'll have less time, but we have more than 30 minutes, I think. So now, in specific, if you have any questions related to creating of IP as well, so related to patent search, patent drafting and filing, the pre-examination publication, the examination request in Tatkal means like early examination request, and after the examination report, so how it need to be responded. So these things we can discuss. If someone in the group or in the audience, if someone has patent applications pending or startups, if they have any ideas they want to first go for patenting before they graduate, so then maybe they can think later, after maybe 1 2 years, they can think of whether to start a enterprise or maybe they can have this IP worked under licensing or maybe other forms of commercialization. So any specific questions I can answer, and I can go back and into some slides as well.